Mr. Speaker, sir, may I have your permission to answer all the parliamentary questions related to the recent incidents of cheating by trainee lawyers during the 2020 bar exams together. That would include questions 3, 4, 5 in the order paper from Mr. Sia, Ms. Hay, Ms. Hany Soh, as well as a written PQ number 11 from Mr. Ang Wei Nang, filed for today's sitting.
Please proceed.
Thank you, sir. So the Singapore Institute of Legal Education, SILE, conducts the bar exams in Singapore. And SILE has said that it has put in place additional safeguards to prevent cheating. It has introduced remote proctoring for exams that are conducted online. And SILE's position is that apart from the 11 cases which have been uncovered, they have not found any other cases of cheating in the subsequent rounds of the bar exams. But of course, the fact that there is a difference between whether it has happened and what they have found, but they haven't found anything else. As regards these particular trainee lawyers, SILE has required that all of them who cheated are required to repeat the preparatory course and or the bar exams in the next year. The Attorney General has objected to the applications for admission because of the cheating during the bar exams. And the court has adjourned their hearings for admission. So what does that mean? It means that the applications to be admitted to the bar will be heard at some time in the future when the adjournments end. And to get admitted, they will need to convince all the stakeholders involved that they are fit and proper to practice law before they are allowed to do so. And as with all admission applications, the High Court has the discretion to rule on whether a particular applicant should be admitted or should not be admitted, taking into account the views of the Attorney General, SILE, and the Law Society. Now, I think we need to be careful about how much we discuss here, and I have to be careful about what I say, because the applications of the trainee lawyers who cheated are still pending in court. So in the circumstances, what I can say is this: lawyers are fiduciaries. They are expected to act in the best interests of the client they advise. They are also officers of the court, meaning they owe a very high duty to the court, and they have to be honest both with their clients and with the court. And they have to act with the highest standards of probity to ensure that they can be relied upon with utmost confidence. And that's not just as lawyers advising clients, but in every other aspect of their conduct. Cheating is a serious derogation from the basic principle of honesty. And I think all this can be said without too much contention. And there are levels of seriousness when lawyers behave dishonestly. Misleading clients is serious, lying in court is serious, lying on oath is serious. And some of these carry potential criminal consequences. There's also other conduct which, if it's unbefitting of a lawyer, whether or not in the context of advising a client, can also be taken up. So these are basic principles, and I'm sure members, including the members who have asked the questions, would accept that any such conduct is quite unacceptable. What happens to the particular trainee lawyers' applications, how they will be dealt with, the courts will decide, taking into account the views of the respective institutions which will put forward their views. Thank you, sir.